Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everybody and Happy New Year. I hope 2021 has started well for you despite the lockdown. It's looking like there is light at the end of the tunnel with the vaccine rollout, so let's keep our fingers crossed. To ease into the podcast year, I'm going to start the 2021 podcast series by talking about a couple of interesting Pensions Ombudsman determinations. The first relates to a decision where the Ombudsman held that a payment of missing contributions, including interest, meant that there was no financial loss, and the second relates to a decision where the Ombudsman held that an employer's failure to pay deducted pension contributions consisted unjust enrichment. So starting with the financial loss determination, this involved a member referred to as Miss X. Miss X was employed by Comfy Quilts in November 2016 and, due to an administrative error, was not automatically enrolled into its pension scheme. As a result, this meant that no employee contributions were deducted from her salary and no monthly contributions were paid into the scheme for her. On the 1st of April 2017, Miss X's employment with Comfy Quilts was transferred to e-bedding in accordance with the Transfer of Undertakings Protection of Employment Regulations 2006, or what we more commonly refer to as the TUPE regs. It's worth noting that Comfy Quilts and e-bedding were part of the same corporate family, and this transfer of Miss X's employment did not change that. Now, it turns out that e-bedding also failed to automatically enrol Miss X into its pension scheme, although it did deduct the contributions from her salary. Yet again, no monthly contributions were paid into the scheme for her. In May 2017, Miss X raised concerns about her pension provision. In January 2018, the Comfy Quilts management team took over the common management of both e-bedding and Comfy Quilts. At that point in time, Miss X's pension contributions in the e-bedding bank account were paid over into the Comfy Quilts scheme. Comfy Quilts also complied with Miss X's request to pay her the missing contributions, as well as interest, from the period from November 2016 to March 2017, i.e. her period of employment with them. Miss X complained that both Comfy Quilts and e-bedding had failed in their obligation to automatically enrol her into the pension scheme in accordance with her contracts of employment, adding that the delay in making the contributions to the scheme had caused a loss of interest that would have been due had the funds been paid into the scheme in a timely manner. Miss X also alleged that by holding her pension contributions in the e-bedding bank account, the companies had financially profited from the interest growth. The employers responded by stating that they had acted in good faith and that there had been no intention to hold on to Miss X's contributions and that they had not financially benefited from those contributions. Comfy Quilts also added that when calculating the interest of her late contributions, it had opted for a higher interest rate of 6% to ensure that Miss X had not suffered any financial loss. The Pensions Ombudsman dismissed Miss X's complaint and followed the earlier opinion of the adjudicator. The Ombudsman held that the failure to automatically enrol Miss X had constituted maladministration by both Comfy Quilts and e-bedding. However, the Ombudsman acknowledged that the missing contributions had been paid into the pension scheme in June 2018, along with interest, which exceeded the interest that the Ombudsman itself would have awarded if required to do so. eBedding had also invested all of Miss X's contributions into the scheme and had promised to perform a unit adjustment calculation to determine the loss of investment that arose from the delayed contribution payments. Comfy Quilts had also given Miss X the opportunity to pay her missing employee contributions, but she had chosen not to do so. The Ombudsman was therefore satisfied that the employers had taken steps to rectify their errors and put Miss X back in the position she would have been had there been no maladministration. Therefore, Miss X had not suffered any financial loss. This determination makes it clear that employers will occasionally make mistakes, but what an employer does when a mistake is discovered to put it right is very important. Moving on to the unjust enrichment determination now. This involved Miss R. Miss R was employed by a nursery which was required to comply with automatic enrolment obligations. The employer nursery was named Jigsaw Elston Limited, which I will refer to as Jigsaw for short. Jigsaw had previously been known as Early Years Learning Academy, which I will refer to as Early Years. When the employer nursery was known as Early Years, it had enrolled Miss R into the Smart Pension Scheme. When the employer nursery rebranded itself to become known as Jigsaw, it enrolled Miss R into a new pension scheme set up with the National Employment Savings Trust, i.e. NEST. Miss R brought a complaint to the Pensions Ombudsman on the basis that the employer nursery had not paid all the necessary employer and employee contributions to Smart Pension and/or the new scheme with NEST. The Ombudsman held that, based on the evidence available, it seemed that Miss R's employee contributions had been deducted from her salary, but not paid across to the appropriate pension arrangement, and neither had all the necessary employer contributions been paid to the appropriate pensions arrangement by the employer nursery. This is clearly a breach of pensions legislation and the employer's nursery automatic enrolment obligations. However, the Ombudsman went further. He noted that Miss R had been given information by the nursery employer which indicated that action was being taken to correct the position. Therefore, the employer nursery's failure to pay the contributions across to the appropriate pension scheme amounted to unjust enrichment. The Ombudsman ordered that the employer nursery should pay the outstanding unpaid employee and employer contributions to the relevant pension scheme, pay an amount equal to the loss of investment gains from the due date of each contribution to the date of actual payment, based on the assumption that the contributions had been paid on the date due and invested in Mrs. R's chosen investment fund, pay any applicable reasonable administration fee charged by the pension arrangement to calculate the investment loss, and also pay Miss R £1,000 in respect of serious distress and inconvenience suffered. This determination reinforces the point that employers should ensure compliance with automatic enrolment obligations and that they have to make sure they have suitable administration processes in place. It is important not only to have such processes in place, but to frequently check them and ensure that they are doing what they were set up to do. That concludes this episode. Please feel free to email me with any comments or questions on this episode to bbrown@mayabrown.com. This is a summary of the law, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances. Thank you for listening.